Well, I guess I have to add my own caveat that my voice is a little hoarse too. So you've had Lauren Bacall because of hoarseness. Well, I guess I'm Humphrey Bogart, huh? Okay, so I'm going to talk about the right to be forgotten. And I'm sure many of you, if not all of you, have heard of this famous case that occurred earlier this year in the European Union, and we're going to focus on that and then try to spin it a little further beyond that. You know, the right to be forgotten is also known as the right to oblivion. Oh, I'm sorry, that's the wrong slide. Indeed, it is called the right to oblivion in some of the texts and some of the commentaries and some of the court opinions that talk about it as well. I kind of like that concept. So, what's the worldwide fuss? I'm going to actually read this out loud because it kind of got to get through it with the right emphasis on the syllables. So on May 13th, 2014, the European Court of Justice held that the operator of a search engine, Google, is obliged to remove from the list of results displayed following a search made on the basis of a person's name links to web pages published by third parties and containing information relating to that person if such information is, quote, inadequate, irrelevant or no longer relevant, or excessive, unquote, in relation to the purposes for which the data was collected or processed and in the light of the time that has elapsed, even if the information is true. So, that's what the fuss is about. It is generally perceived as a kind of David and Google-iath kind of competition. Mario Costeja Gonzalez is the David, and Google is the Google-iath. So the decision, and this is actually the full name of the case, because it was an appeal by Google in Spain and Google Inc. worldwide against the Spanish Data Protection Agency, which was the regulatory agency that supported Mr. Costeja Gonzalez's case. And what the case is really about is not so much the privacy itself, because that was really a foregone conclusion from the Data Privacy Directive, which I'll tell you about in a second. But what the case really established as a precedent was that Google, as a search engine provider, was responsible for the results of the searches. And that's what the case was really, really, really about. It's not so much that a person in Europe has a right to get rid of certain information about that. That was kind of a foregone conclusion. But it's the fact that Google and any other search engine provider is stuck with the responsibilities that a controller of this information would have, the website provider. So it's big deal in that regard and shifts the responsibilities quite handily. Quick factual background. In 2009, Mr. Costeja Gonzalez discovered that if you did a kind of internet selfie and asked, whoa, what are people saying about me? What does my name appear in? It pulled up two old newspaper articles about him, or really about the fact that he had been in debt for not having paid some governmental tax or something. And so they ordered his property put up for sale. Well, kind of a big deal. I'm sure it was disturbing to him. But he settled it. It all got taken care of 15 years ago. But The newspaper articles lived on in the internet, and if you did a search on his name, whatever else came up, you got these 2 newspaper articles. So he went to the newspaper and he said, you know, guys, this is old history. Would you please remove them from your archives? Take it down off the internet. They refused. He went to Google and he said the same thing. They refused. So he went to the Data Privacy Agency in Spain, which every country in the EU has set up a data privacy regulatory agency pursuant to this data directive. And he said, you got to help me, guys. And they said, okay, see. And they held 2 things. Interestingly, they said, well, the newspaper doesn't have to do anything because it's a legitimate reporter of things that happen. It's a record, a chronicle of what happened. And so it doesn't have to do anything. It properly reported that news. But when Google runs its machine and pulls those newspapers up, now it's got a different responsibility. It's not protected by the equivalent in Europe of the newspaper First Amendment. It's parlaying what's on the internet for money, and now they're putting it out there, and the court says they're going to be liable for that. And they did all this within the context of this data directive. In the EU, as you may know, a directive is the word they use instead of legislation. It's a product of the co-responsible system in the EU, which is a little bit esoteric, but there's a parliament, and they have a council, and the 2 of them have to go back and forth and agree. It's kind of like the Senate and the House of Representatives. They go back and forth and eventually agree on compromise legislation, and that's called a directive. So you have this data directive. Whoops, sorry. So there's 2 provisions of it, Article 6.1 and 12b. The first one is the one, and you'll recognize this language, and says that member states of the EU, must provide that personal data must be adequate, relevant, and not excessive in relation to the purposes for which they're collected and further processed. And D, they must be, accurate and where necessary, kept up to date. It's a responsibility that the states put upon anybody who is going to be deemed a controller of information. 12 gives the remedy. Member states shall guarantee every data subject, that's me or you, the right to obtain from the controller of this data, as appropriate, the rectification, erasure, or blocking of data, the processing of which does not comply with the provisions of this directive, e.g. 6.1, in particular because of incomplete or inaccurate nature of the data. So, if you find information about yourself and you are a European citizen, you can, if the data meets this test, this inadequate, irrelevant, excessive, inaccurate, un-up-to-date, if you can prove this data meets this test, or tests, plural, then under 12, you can ask for the rectification, erasure, or blocking of the data. So, what's the interplay between these? This is what the court says, is that this processing of personal data carried out by the operator of a search engine is liable to affect significantly the fundamental rights of privacy and the protection of personal data, since that processing enables any internet user to obtain information which potentially concerns a vast number of aspects of an individual's private life, and which, without the search engine, could not have been interconnected or could have only been with great difficulty. So the search engine is the enabler of the publication of the inaccurate, inadequate, ineffective, irrelevant information. And so therefore, the operator of this search engine has got special responsibilities. Now, the court emphasized that there is need for a balance in the process. So when you complain to a controller of data that it's not accurate or adequate or et cetera, then the operator has to go through a balancing test to figure out whether the data is so harmful to your rights as the subject of the data that it outweighs the public's interest in the information. Now, that's a kind of awesome responsibility, but that's the way the court has figured that this is the best way to do it. We're going to let the controller, in this case Google, make these decisions. The subject of the data applies, says, I got this problem, please take it down. Google thinks about it, they do this balancing test and somehow, and then they make a ruling. And if they make, in the data user's mind, the wrong ruling and leave it up, then they can go to their local privacy agency, as did Mr. Costeja Gonzalez. So how do you do this balancing? Oh, this is a black box. It depends on the nature of the information in question and its sensitivity to the data subject's private life, and on the other hand, on the interest of the public in having that information. Does the public really need to have this information from 1998 about Mr. Costeja Gonzalez's property problem? The court said, no, not really. And his interests override the economic interest of the search engine. What would that be? Well, that would be, it costs money to run this balancing test. It costs money for us to go and pull this information out and program our computers so it doesn't pop up when Mr. Costeja Gonzalez's name is plugged in. Well, that's too bad. You know, you do this for a living, you gotta live with this. And that's the economic interest of the search engine operator and the general public's interest in the data about him. So where are we in Europe? On request of an individual to remove information about him, the controller must do this balancing test. And trying to live up to its court-ordered obligations, Google has dutifully published an online form that you can fill out and submit online to request removal of data links. The first day this went into operation, there were 12,000 requests. As of July, there were 70,000 requests. Okay, this, from the Google's point of view, there's an economic interest here, you know? So there's been a lot of reactions. I mean, I spent time flipping through all these things, and I'm thinking, oh man, I could quote for an hour on either side of this. But here's just a few. Well, first off, Google sent a SWAT team out of scholars and lawyers and others to go around holding seminars in essentially every city in Europe, every major city in Europe, to explain why this was unnecessary, why it was a terrible burden, why it was just a disaster. Wikipedia co-founder Jimmy Wales, who constantly pops up on my screen asking for money, had an interview in a newspaper, and he called the EU's decision deeply immoral and warned that the ruling will result in an internet riddled with memory holes. Pretty good imagery, I like that part. Another legal commentator characterized the judgment as profoundly harmful to the operation of the internet and a betrayal of Europe's legacy in protecting freedom of expression. Ooh, harsh words. Another guy says it's a draconian attack on free speech. Someone else called it retrograde, akin to, and I know you'll like this, marching into a library and forcing it to pulp books. Who would do that other than the local county board? But there's lots of positive statements as well. A leader of the UK Parliament praised the decision, saying the presumption by internet companies that they can just use people's personal information in any way they see fit is wrong and can only happen because the legal framework in most states, he means countries, is still in the last century when it comes to property rights and personal information. And a Privacy Act, I mean, I like this phrase too, without the freedom to be private, we have precious little freedom at all. I mean, Tom Paine could have said that if he lived in the internet age. So what do I think? I know you really want to know what I think. I think it's a great decision. A careful and correct application of the EU data privacy law, and it recognizes the need to balance all interest, not just say, well, whatever the internet controller wants to do. More than that, I see it as a vital first step in trying to bring the insanity of the internet under control. It's already destroyed legitimate newspapers. It is now gutting libraries. It's easier to find porn and libel on the internet than Shakespeare. And it's all well and good to worship free expression, but you cannot yell fire in a crowded movie theater just because you're expressing yourself. We need to get control of this Wild West now before it gets worse. But hey, you know, it's just me talking. So who cares about Europe? Europe, schmerup, what about the US? Could Google happen here? Maybe, maybe not. We don't have any broad-based law like the Data Directive. We don't have anything in the Constitution that you could hang a hat on and say that a data controller has to remove or take down data that's irrelevant or inaccurate. Now, sometimes our legislatures do step in. We do regulate data use and content in one notable area, credit reporting. The Fair Credit Reporting Act imposes certain rules on accuracy, relevance, and obsoleteness. Maybe we need a Fair Credit Reporting Act that's much broader and goes well beyond credit reporting. Is there any other remedy right now? Well, in general in the United States, we recognize a hazy kind of invasion of privacy. Some states prohibit use of a name or likeness for advertising without consent. And there's defamation and slander laws, but those require proof of intent to harm and damages, elements that were not required under the Data Directive in the EU. There's even a tort called intrusion upon seclusion. You know, that's so poetic, but it doesn't get used much because it's kind of a trespass theory. There is another one, and I think it may be the best shot if you were going to try to bring some kind of lawsuit: public disclosure of embarrassing private facts. Well, that would fit. And how about Canada? You know, Canada's kind of like the U.S., right? I think it's part of the U.S., I'm not sure. But there was a judge in British Columbia that ordered Google, well, poor Google, at the target again, to block a group of websites from its worldwide search engine. Now, the EU decision only relates to Google in Europe. That is to say, only, you know, sites in Europe. But this order from this Canadian judge applies to the entire world for Google, and it isn't even a privacy case. It's a trade secret case where someone wanted an injunction to protect its trade secrets, and the judge perceived Google as, in effect, being an unwilling and unwitting facilitator of these trade secret violations. So you, my friends, are dedicated to preserving information, printed information in books and periodicals, information on CDs and DVDs, as well as ebooks. And of course, now every library is filled with computer terminals for patrons and scholars and students to access e-information online. And I know it tears your hearts out to have to discard old books and magazines into the dumpster to make room for the new. But what about bad or private info? What do you say when someone asks you to help them take down false, old, or embarrassing information? A weird guy comes in and asks you to delete a particularly embarrassing photo from the internet. He says he's a different person now. What do? Well, you might offer him a Lethe cocktail. Lethe, as you know, is the river in the Greek underworld that when drunk from made souls forget the sufferings of life. Oblivion, there's that word again. Or something to make you enter oblivion and forget. Now, that may not work. But you could try Notice and Takedown. And certainly all of you may have already had experience doing this. Most online hosts offer procedures for requesting that they voluntarily remove or take down material. You can go on their websites. You can go on, for example, YouTube. You know, if that photo was part of a YouTube and some music was playing behind it, I could probably get them to take it down because it's obviously pornography. And in fact, Notice and Takedown is part of the Digital Millennium Copyright Act for copyright-related violations. But the other thing that you can do, and this is really what I'd recommend, is you get on the phone and you call Google and you say to him, "Forget him, 'cause he doesn't want fame. Forget him, 'cause it isn't fair. Don't let them search for his old data, 'cause they can't find the dirt that isn't there. Google guy, I'm asking politely, remove those links so they can't see. Oh, don't you cry now, just be a good guy now. Forget him and guard his privacy."